Alright, let's talk about something you probably haven't thought about since that one science class where you grew a bean in a wet paper towel. Seeds. They're tiny, they're dusty, they're the basis of all human civilization. For thousands of years the deal was simple. You grow a plant, you take some seeds, you plant them again next year. It's a cycle as old as time itself. But what if I told you that simple act could now land a farmer in court, facing financial ruin? Yes, that's right. Saving seeds can be treated like massive-scale piracy, but worse for our food supply. It sounds insane, doesn't it? Like banning someone from refilling their own water bottle. Welcome to seed patenting. Massive corporations don't just sell seeds, they license them. Think of it like renting a movie on a streaming service. You get to watch it once, you don't own it, you can't make copies. Now apply that logic to the thing that grows our food. Farmers buy seeds and grow a crop. At harvest, the seeds produced don't belong to the farmer. They belong to a company with a patent claiming this tiny speck of potential life. Yeah, that's ours. All of it. Forever. A shared natural heritage turned into a tightly controlled commodity. This isn't niche. It's the operating system of modern agriculture. The vast majority of staple crops in the US, like corn, soybeans, cotton, a handful of colossal agrochemical companies have unprecedented control over what is grown, how it's grown, and who profits. 10,000-year tradition upended in decades under the guise of innovation. So, how in the world do you patent a seed? It seems absurd, right? It's like trying to patent the concept of blinking the feeling of existential dread you get on a Sunday night. But, oh, it's very possible. And it's the legal bedrock of this entire mess. The key is the utility patent. For most of history you couldn't really patent life. The patent office would basically laugh you out of the room. Then everything changed with a landmark 1980 Supreme Court case, Diamond v. Chakrabarty. The case involved a genetically engineered microorganism that could eat oil. The court ruled, in a narrow 5-4 decision. The decision famously said, anything under the sun that is made by man is patentable. That opened the floodgates. Agrochemical companies saw their golden ticket. They realized they could create GMOs and own them completely. Scientists would insert specific genes into a plant's DNA to give it desirable traits. Herbicide resistance, pest resistance. This human intervention was the made-by-man loophole to secure a utility patent. Utility patents are far more powerful than plant variety protection. A utility patent covers the plant, its seeds, its traits, its genetic material, any future generations. When a farmer buys a bag of patented seeds, they aren't buying the seed in the traditional sense. They are signing a technology licensing agreement. It's a lengthy contract, full of dense legalese, that explicitly forbids them from saving any seeds from their harvest for replanting. They are only granted the right to plant for a single season. The contract turns the farmer from owner into renter. They are leasing the genetic information for one growing cycle. The company retains ownership of the genetics and every seed produced. If a farmer saves and replants, they breach the contract. Patent infringement. A handful of seeds enough for 1,000 acres. The law treats it as theft of intellectual property. Companies have very, very deep pockets and use legal teams to enforce agreements with terrifying efficiency. It's a system that forces farmers back to the company store year after year after year. This whole situation didn't just pop up overnight. It's the result of a slow, deliberate corporate strategy that played out over decades. Before the 1980s, the seed industry was a diverse landscape. It was populated by hundreds of small, often family-owned, regional seed companies. These companies developed seeds through traditional breeding methods, creating varieties well-suited to local climates and soils. Farmers had a wide array of choices. The idea of a company owning a seed was largely foreign. The primary business was selling a good product, not legally forcing them to. It was a competitive market based on performance, not patents. Then came the chemical giants. Monsanto, DuPont, Dow, which had made their fortunes in chemicals and pesticides, started looking at the seed market in the 1970s and 80s. They saw a massive opportunity. Why just sell the chemicals to protect the plant when you could sell the plant itself? And even better, why not engineer a plant that was dependent on your specific brand of chemicals? This was the genesis of the Roundup Ready system. Monsanto developed seeds genetically engineered to be immune to Roundup. It was a brilliant, if diabolical, business synergy. You sell the farmer the seed, then the only chemical that won't kill it. Following the Chakrabarty decision, these companies went on a shopping spree. Throughout the 1990s and 2000s, they systematically bought up hundreds of smaller independent seed companies. They weren't just acquiring businesses, They were acquiring genetic libraries. They consolidated the market at a breathtaking pace, snapping up competitors and their valuable seed varieties. This transformed the industry from a diverse marketplace into an oligopoly where just a few players controlled the vast majority of the seed supply for major commodity crops. Today the Big Four, Bayer, Corteva, Syngenta, BASF, dominate the global seed and pesticide markets. So what actually happens when a farmer is suspected of breaking the rules? Well, you might imagine a sternly worded letter. You would be adorably mistaken. Enforcement is down to a science. It often starts with a tip. Companies like Monsanto ran tip lines. Ads in rural magazines encouraged reporting neighbors. It's a dystopian neighborhood watch for beans. See something, say something, new meaning, tips from rival farmers, tips from disgruntled employees, tips from local seed dealers who notice purchases dropped off. Company gets a lead, launch an investigation. Not just phone calls from guys in suits. Private investigators show up. Field agents appear. The whole process feels intimidating. Investigators might fly over fields. They take aerial photographs. They may sneak onto property to take plant samples for genetic testing. They trespass to collect evidence. They claim pollen and seeds can drift. Farmers feel paranoia and fear. Imagine a stranger snipping leaves into a plastic bag. It's straight out of a rural thriller. If patented genetics are found where they shouldn't be, the legal hammer comes down. The company's lawyers send a patent infringement letter. Farmers are given a choice: settle out of court, or face a federal lawsuit. Settlements mean hefty fines, tens of thousands, or hundreds of thousands of dollars. Settlements often require destroying the offending crop, and signing agreements to allow inspections, inspect their fields, inspect their records for years, often without a warrant. It's meant to make an example. For a farmer, this is a nightmare. Most run on razor-thin margins. Many are deeply in debt. They can't afford a legal battle with a multi-billion-dollar corporation and an army of lawyers. Defense costs can be ruinous, even if innocent. Facing settlement or annihilation, most settle. The message: don't mess with us. The system punishes and terrifies others into compliance. This isn't just a theoretical problem, it has destroyed real lives and livelihoods. Percy Schmeiser, a canola farmer from Saskatchewan, Canada. For years, Monsanto pursued him, claiming he had illegally planted their Roundup-ready canola. Schmeiser maintained he never bought their seed. The patented genes had blown onto his property from neighboring farms, or maybe even fallen from passing trucks. He argued he shouldn't be held responsible for accidental contamination. A David and Goliath fight. Schmeiser, a 70-year-old farmer, versus a corporate behemoth. He fought all the way to the Supreme Court of Canada. The court's final decision in 2004 was a devastating blow. They acknowledged Schmeiser didn't profit. But they ruled it didn't matter how the patented seeds got into his field. The mere presence of the patented gene constituted an infringement. He harvested and sold the crop. So he was guilty, the court said. He wasn't required to pay Monsanto's tech fee because he hadn't profited. But the ruling set a terrifying precedent. Farmers are liable for contamination they cannot control. The wind blows, pollen drifts, the farmer pays the price. Schmeiser spent hundreds of thousands of dollars in a decade fighting, becoming a global symbol. Then, Vernon Hugh Bowman, an Indiana soybean farmer. Bowman's case shows how far patent control reaches. He bought Roundup-ready soybeans for his main crop each year, as his contract required. For a late-season second planting, he went to a local grain elevator and bought commodity grain, the unlabeled mix of soybeans from many farms. He reasoned most of it would be Roundup-ready, planted it, and sprayed Roundup, killing the non-resistant plants. Monsanto sued him. They took the case to the U.S. Supreme Court. In 2013, the court ruled unanimously against Bowman. They said patent protection wasn't exhausted after the first sale, and that he had infringed the patent. The decision solidified the company's power, extending control to second generation, third generation, subsequent generations, no matter how the seed was acquired. These cases sent a shockwave through farming communities, proving no clever workaround existed. The message was clear: if it contains our gene, it belongs to us, period. For literally 99.9% of agricultural history, saving seeds was not just a practice, it was the very foundation of farming. It was an act of co-creation between humans and nature. Each year, farmers would walk their fields and select seeds from the hardiest, tastiest, most productive plants. They were amateur botanists and geneticists, constantly adapting their crops to the unique conditions of their land. Over millennia, millions of farmers created an incredible diversity of crops. thousands of varieties of corn, wheat, tomatoes, potatoes. Each variety a living library of genetic information tailored to a place and culture, agricultural biodiversity in its purest form. This tradition meant more than economics, resilience, knowledge, independence. A seed-saving farmer was self-sufficient, not dependent on distant corporations. They held their survival in their hands, knowledge passed from parent to child. A sacred trust. Saving seeds was hope and a commitment to the future. It was a partnership with the land. Your grandmother didn't sign a 12-page licensing agreement before she saved tomato seeds from her garden. It was just common sense. This tradition built food security from the ground up. Now contrast that with today's legal reality for a commercial farmer. The act of saving seeds has been reframed as a crime. Patent infringement. Farmers become end users of a patented technology. Seed selection knowledge has become irrelevant for many. Why learn to select the best plants when you're legally required to buy new seeds every single year? This severs a connection as old as civilization. Power and autonomy move from farmers into corporate vaults. The result? Loss of culture and biodiversity. Patented, uniform varieties dominate the landscape. Thousands of locally adapted varieties extinct or vanishing. We're erasing a 10,000-year genetic library, trading resilient diversity for fragile uniformity for corporate profit and control. The death of seed saving is an ecological and cultural tragedy. We've replaced the wisdom of generations with the terms and conditions of a contract. You don't have to take my word for it. Farmers, agricultural experts have been sounding the alarm on this for years. They speak of a climate of fear and the suffocating feeling of being controlled. As one advocate summarized, "We've turned a common heritage into a private commodity, and we're all paying the price for it."